Can a star young private criminal defense attorney get a serial DUI offender off the hook on his fourth DUI? In this video, we will show you the full 2021 trial in the case of State of Florida versus Matthew Thomas Zaleski in Tallahassee, Florida, which regards a 2018 DUI arrest. At trial, Mr. Zaleski was represented by a private attorney, Aaron Waite, talented young attorney who specializes in criminal defense work. The main prosecutor on the case was Mr. Robert McLean Edwards. The judge presiding over the trial was the Honorable Judge Jason Jones. Matthew Thomas Zaleski, the defendant, is an engineer who worked at GPI Southeast at the time of his 2018 arrest. He is currently 41 years of age. According to the arrest warrant affidavit in that case, Mr. Zaleski had a long history of trouble with the law due to alcohol consumption followed by a decision to operate a motor vehicle. According to the report, Mr. Zaleski had prior DUI adjudications of guilt on June 21, 2006, when he was 23, on April 19, 2009, when he was 26, and on November 4, 2010, when he was 28. This particular trial involves Zaleski's fourth arrest for DUI, at least as far as we know, which took place on Tallahassee Road in Tallahassee, Florida, on September 3, 2018. The details of that incident will be disclosed in the opening statements of the trial. You should know that during the interactions he had with law enforcement during that 2018 arrest, he admitted to having had 2 drinks while out with friends. He then refused to take a breathalyzer test. He was then arrested for DUI. Alright, let's watch the trial, which took place in June of 2021.
All rise, court's now in session. The Honorable Jason L. Jones presiding.
Everyone have a seat. All right, so we got everything working, all the technical stuff.
Yes, Your Honor.
State ready to proceed?
Yes, sir.
Defense ready to proceed?
Yes, Your Honor.
Okay. And we are back on the record for State versus Matthew Zaleski, case number 2018 CT 1871. Any preliminary matters before we bring the jury in?
Nothing to say.
Mr. White?
No, Judge, just going through the previous motions to suppress from the previous trial. So we asked none of the state's witnesses mention any refusal to submit the field sobriety exercises. From the transcript, there was a discussion at one point about Officer Braxton positioning his car to do field sobriety exercises, and just want to make sure he doesn't mention that again in this trial. We kind of had a sidebar from the transcript, and we just decided to not ring the bell again and just moved on from it. But just making sure Officer Braxton knows this time not to mention anything related to I'm going to do field sobriety exercises.
Okay. And have you had that conversation with Officer Braxton?
I go tell him right now.
Okay. Mr. Wade, are you asking for the rule to be invoked?
Yes, Your Honor.
Mr. Edwards, have you explained to the witnesses that they're under the rule of sequestration?
Yes, sir.
All right, so are both sides ready to proceed?
Yes, Judge.
Yes, Your Honor.
Bring in the jury. While we're waiting for the jury to be brought in, I have a note from digital to remind you to please speak into the microphones and not walk around too much, Mr. Williams.
Yes, sir, Judge.
All rise, jury entering the courtroom.
All right. Everyone may be seated. Ladies and gentlemen, the jury, I'm going to ask you to stand one more time and be sworn in one last time. Madam Clerk, please swear in the jury.
Raise your right hands for me. Do you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and the defendant and render a true verdict according to the law and evidence? If so, say you will. Thank you.
Thank you. You may be seated. All right, we're on the record with State versus Matthew Zaleski, case number 2018 CT 1871. Defendant is present in the courtroom and at counsel table. Is the state ready to proceed?
Yes, Your Honor.
The defense ready to proceed?
Yes, Your Honor.
Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Matthew Zaleski. This is a criminal case. Mr. Zaleski is charged with driving under the influence. The definition of driving under the influence will be explained to you later. The state's charging document, which is called an information, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Mr. Zaleski in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding any further, it will be helpful if you understand how a trial is conducted. At the beginning of a trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorney the chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may also be produced as evidence. After the evidence has been presented, the court will give you instructions on the law. The attorneys will then have an opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will conclude with the final instructions. After the final instructions are given, the alternate juror will be released, and you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case amongst yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communications include no emailing, texting, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of these rules at all, notify court personnel of the violation. During the course of the trial, the court may take recesses and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone or permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the courtroom deputy or any deputy that you might see, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom. Turned off means that the phone or other electronic device is actually off and is not on silent or vibrating mode. You may use these devices during recesses, but even then you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check and make sure that your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you. The case must be tried by you only on the evidence presented during the trial, in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation on their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any places discussed during the trial. Jurors must not have any discussions of any sort with friends or family about the case or the people and places involved. So do not let even the closest family member make comments to you and ask you questions about the trial. In this age of electronic communication, I want to stress again that you must not talk to anybody about this case face to face. You must not talk about this case by using electronic devices. You must not use phones, computers, or electronic devices to communicate. Do not send or accept any messages related to this case or jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtained is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these instructions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of the defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what may have occurred had that objection been not sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such a conference occurs, they will be conducted so as to consume as little of your time as necessary for a fair and orderly trial of the case. If you would like to take notes during trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You will be provided with a notepad and a pen if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courthouse. During recesses, the bailiff will take possession of your notes and return them after we reconvene. After you have completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed. No one will ever see your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used as an aid to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than a juror's memory of the evidence. Mr. Edwards, do you wish to make an opening statement?
Thank you, Your Honor. May it please the court. Opposing counsel. Good afternoon, members of the jury. My name is Richard Adetutu, and I am a certified legal intern with the State Attorney's Office, and I will be assisting Mr. Edwards today during this trial. This morning at jury selection, we talked about concepts. Now we get to talk about the facts of this case. The case before you today is a charge of driving under the influence. Now, as we discussed in jury selection, there's a difference between impairment and drunkenness. The evidence in this case will show that on the 3rd of September 2018, the defendant was driving a motor vehicle while under the influence to the extent that his normal faculties were impaired. During the course of this trial, you're going to hear testimony from Officer Elizabeth Smith of the Tallahassee Police Department. She will tell you that on the 3rd of September 2018, at around 10:18 p.m., while she was on routine uniform patrol, around Thomasville and Burton Road, she noticed that a white Ford Ranger driven by the defendant did not stop at the stop bar at the traffic light. Instead, it went all the way into the intersection. She will tell you that when that happened, the defendant almost struck out another car traveling west. Once the light turned green, Officer Elizabeth Smith will testify that the car sped off, running over 15 miles per hour above the posted speed limit. It was then she decided to follow. She noticed while she followed the defendant's car that he was weaving in and out of traffic and swerving within its own lane. She would also testify that 3 different times the car struck the median, and that on the 3rd time the car struck the median, it swerved back so hard into its lane that it almost hit the car traveling on the lane next to it. It was at this point, after she'd made all these observations, she decided to initiate a traffic stop. Officer Smith will also testify today that as she approached the vehicle, the defendant said, and I quote, "I live off the road. Is there anything I can do to fix this?" Officer Smith will also tell you that while she was talking to the defendant, she noticed a strong smell of alcohol coming from his breath and that he also had glassy eyes. Based on her observation, that's when she decided to call for backup. Now, today you would also hear from Officer Derek Braxton from the Tallahassee Police Department. He was the one who responded to Officer Smith's call for backup. Officer Braxton is going to testify today, he's going to tell you today during the course of this trial that when he arrived and he started talking to the defendant, he noticed that he was swaying as he was standing talking to him, he was swaying. And he also perceived a strong odor of alcohol coming from his breath. And Officer Braxton is also going to tell you that while he was speaking with the defendant told him that it was coming from Midtown Caboose and he had had 1 or 2 drinks. And Officer Braxton will also tell you today that it was because the defendant showed signs of impairment that Officer Braxton recognized based on his experience and training, he decided to place him under arrest. I believe also today that Officer Braxton will tell you that when they got to Leon County Jail, he asked the defendant to submit to a lawful test of his breath. He refused. Even after I told him that if he did not, his license would be suspended for a year, the defendant refused. Members of the jury, you will not only hear Officer Braxton's testimony today, you would also get to watch the video encounter between Officer Braxton and the defendant on this said day. As it was said earlier today, the burden of proof in this case is beyond a reasonable doubt. Not beyond every imaginable, speculative, or forced doubt, but beyond a reasonable doubt. What this simply means is that if you have any doubt, it has to be rooted in reason. The burden of proof today, the state gladly bears. Because after hearing and seeing all the evidence in this case today, we are confident that you will be compelled to find the defendant guilty. Thank you.
Thanks, sir. Mr. Waits, does the defense wish to give an opening statement?
Yes, Your Honor. Good afternoon. As the state just told you, this is our opportunity as the lawyers to tell you what we expect the evidence will show. And so we get to tell you what we expect you to see and hear. the state just said, I expect your first hear from Officer Elizabeth Smith. And she's going to describe to you first seeing Mr. Zaleski's vehicle. She's going to tell you that she was sitting on Benton Road with Thomasville going south to north in front of her. So facing away from the park in Benton Hills as his vehicle was going left to right. A year later, Mr. Zaleski tells Officer Braxton that he was going from Midtown Caboose with a couple friends. After a couple hours, so he had a couple drinks. But you'll see, or you'll hear from Officer Smith that Mr. Zaleski's vehicle comes all the way almost in the middle of the intersection and almost hits somebody. And I expect you'll hear that for some reason Officer Smith will tell you she didn't hit her lights and stop Mr. Zaleski's vehicle dead. I anticipate you'll hear that Mr. Zaleski's vehicle was apparently in the middle of traffic, stopped in the intersection at the red light, and she didn't hit her lights at all. I anticipate you'll hear that when the light turned green, Officer Smith will tell you that Mr. Zaleski's vehicle took off north, and Officer Smith got in behind that vehicle. I anticipate you'll also hear that Officer Smith will tell you about 300 yards down or 300 feet down the road, so a football field, not even getting to the SunTrust or Shell gas station, that he hit a curb. He hit the curb. And for some reason, I expect you'll hear that Officer Smith didn't hit her lights to pull Mr. Zaleski over. I anticipate you'll hear Officer Smith tell you that, as the state said, he was going 60 apparently in a 45-mile-an-hour zone, and for some reason, Officer Smith will tell you she didn't hit her lights for that either. I anticipate you'll hear Officer Smith tell you again that his vehicle hit the curb again and then swerved back again enough to almost hit another vehicle. And I anticipate you'll hear Officer Smith tell you for some reason she again did not hit her lights to pull Mr. Zaleski over. I anticipate you'll hear Officer Smith tell you she had clear view of Mr. Zaleski. Her view wasn't obstructed. She wasn't prevented from hitting her lights to pull Mr. Zaleski over. But it wasn't until 2.5, almost 3 miles down the road at Piedmont, almost approaching I-10 and Thomasville Road, is when the lights were finally activated. I anticipate you'll hear Officer Smith tell you that Tallahassee Police Department has a way to verify officer speed and how fast they're going to catch up with people, and I don't anticipate you'll see or hear any of that evidence today to confirm how fast she was going or how fast Mr. Zaleski was going. I anticipate after you hear this descriptive story from Officer Smith that you'll be left with questions about why, if this person was such a danger to the road, the lights weren't hit until 2.5, 3 miles down the road. I anticipate you'll hear in the testimony that no 911 callers called in from the road, that this apparent vehicle was hitting curbs, almost hitting cars, almost, as Officer Smith will tell you, almost flipping his car at one point, so she said. And you'll be left to have those questions about what really happened, and I anticipate you'll hear that none of this was recorded on a dash cam. I anticipate you'll hear Tallahassee Police Department didn't find it fit to give officers videos and record things until late 2018, 2019. So I anticipate after hearing the evidence you won't be able to resolve the conflicts between Officer Smith's testimony and your own common sense. I anticipate you will hear, as the state said, Officer Smith, again, there's no video, but says that Mr. Zaleski just says, as I look down the road, anything I can do to fix this. Let's put that in context. I anticipate you'll hear Officer Smith tell you that at no point was a DUI discussed at that point. That Officer Smith hadn't discussed where he's coming from, what he had to drink, telling him that she observed an odor of alcohol on his breath. Nothing alcohol related was discussed up until that point, just the reason for the stop. And so I anticipate Officer Smith will tell you that that comment could very well be attributed to just getting out of a ticket. Nothing to do with the DUI, since none of that was brought up at that point. I anticipate you'll hear Officer Smith, or perhaps Officer Braxton, will tell you that they heard slurred speech. You'll be able to hear a video which shows that he doesn't have slurred speech, and you'll even hear some testimony from Officer Smith where she made a statement contradictory about not hearing any slurred speech. But eventually, Officer Braxton does get called to the scene, comes on scene, and starts asking those questions. For the first time to Mr. Zaleski about where you've been, what have you had to drink, and he says, yeah, been coming from Midtown. And you'll hear Officer Braxton immediately jump to the assumption, which bar? As if the only thing in Midtown is bars. You'll hear Mr. Zaleski clarify that it was coming from Midtown Caboose with some friends and had 1 to 2 drinks. And you'll hear him clarify 2 drinks over a couple hours. And this was around 10:30 at night. Again, this is our opportunity to tell you what we expect you to see and hear, and I anticipate you will not hear any testimony about these officers doing any follow-up investigation. I don't anticipate you'll hear any testimony that they then went to Midtown Caboose, spoke with waitresses, spoke with waiters, spoke with managers, got receipts, did anything to follow up, and knowing that this case could go to trial to give you more evidence of what happened. I anticipate after that discussion that Officer Braxton and Mr. Zaleski had, Mr. Zaleski is then placed under arrest, put in handcuffs, put in the back of a patrol car, driven from I-10 in Thomasville all the way to the jail, driven through the gate with barbed wire that comes out, driven through the metal gate that comes up into what's called the Sally Port. That metal gate comes down, and you'll get to see the environment that Mr. Zaleski was in when he exercised his right to decline the breath test. You'll see a video of him in handcuffs being asked whether he wants to take a breath test. And you'll hear him say that he wants to talk to his attorney. I anticipate you'll hear Officer Braxton then read him a statement saying, yeah, you know, yada, 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 his license can be suspended, we can use this in court, I just want to talk to my attorney. And then the officer took that as his refusal to do that, since he couldn't talk to his attorney at that point. So it wasn't until he was inside the Sally Port of the jail, handcuffed, that he exercised his right. And Officer Braxton, I anticipate you'll hear evidence that he exercised his right to decline the breath test. Officer Braxton will clarify for you that it is his right. And I anticipate that will be all the evidence you will see and hear. The only video you will see from the scene is of Officer Braxton's vehicle facing forward towards the underpass of I-10. And Officer Braxton doesn't bring him all the way onto the video to have this conversation. You will get to see Mr. Zaleski, once they arrest him, walk past the video in handcuffs, and you'll see that he's not staggering or stumbling around. And so as the judge will tell you that you can find your reasonable doubt in the evidence, conflict of evidence, or lack of evidence. I anticipate that the lack of evidence in this case, the lack of investigation by the Tallahassee Police Department, the lack of any video equipment to confirm and dispel your common sense when you listen to this evidence, because everything you're going to hear that apparently indicates Mr. Zaleski was impaired conveniently was not captured on video. And then we get a video and he's not staggering or stumbling and he's not slurring his speech. So I anticipate, based on that lack of evidence, based on the conflict of the evidence, and based on the minimal evidence itself, you will be compelled to find Mr. Zaleski not guilty. Thank you.
Mr. Edwards, you can call your first witness.
State calls Officer Elizabeth Smith to the stand.
Officer Smith, if you could just stand in front of the witness stand before you sit down and be sworn in. Can you see the clerk?
You raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, Officer Smith, you can have a seat. Just make sure you stay close to that microphone.
May I proceed, Judge?
You may proceed.
All right, good afternoon, ma'am. If you could introduce yourself to the jury,
My name is Elizabeth Smith.
and where do you work?
I am an officer at the Tallahassee Police Department.
How long have you worked there?
I've worked there for approximately 5 years now.
And can you describe your duties at that job to the jury?
Currently, I'm assigned to the Patrol Division. I respond to calls for service and initiate traffic stops as needed.
During your time there, did you receive any training on the signs of alcohol impairment?
Yes.
If you could describe that to the jury.
I received the general training that all officers do in the police academy on how to recognize signs of impairment and how to initiate traffic stops concerning those.
Any training on recognizing driving patterns of impaired drivers?
Yes, sir.
You could describe that.
It was in the same class.
Okay, all right. Were you working with the Tallahassee Police Department in September of 2018?
I was.
Do you recall the evening of September 3rd of 2018?
I do.
And were you on duty that night?
Yes, I was.
Did you ever come into contact with the defendant in this case?
I did.
All right. What time of night was that?
It was approximately 10 p.m. or probably just a little bit after.
All right. What were you doing at that time?
I was on patrol and I was driving west on Benton Road at the intersection of Benton and Thomasville.
All right. Were you the first car up, or were there cars in front of you at the intersection?
There was at least one car in front of me.
Did you notice anything unusual at that time?
Yes. So as my traffic light to go west turned green, I observed a white truck driving northbound. It failed to stop at the stop bar and came to a screeching halt and almost struck one of the vehicles in front of me.
And after almost hitting this car, what did the white Ford truck do?
So I proceeded through the green light and came to a stop in the parking lot that was right there at the intersection. When the truck's green light to go north came up, he sped off at a high rate of speed.
At some point, did you get behind this truck?
I did.
Okay. Did you have an opportunity to observe his driving at that time?
I did.
All right. If you could describe that to the jury.
So as I was driving, the truck was in front of me. He swerved inside his own lane multiple times. At one point, he struck the median and came back into his lane. He did this 2 more times. On the 3rd time, when he hit the median, he swerved so hard, he almost hit the truck that was in the lane next to him.
And do you know how fast he was going around this time?
Approximately 60 miles per hour.
What is the posted speed limit?
45.
Did you turn your blue lights on and siren at this time?
Not immediately.
And why is that?
So there was heavy traffic that night, and based on his driving pattern, I was afraid that once I turned my blue lights on, that he would either speed off or cause damage or harm another driver.
Were other cars on the road reacting to his driving?
They were.
And how were they reacting?
They were slowing down and trying to stay away from his driving, especially after he hit the median the 3rd time and almost hit the car.
Did you eventually conduct a traffic stop in this case?
I did.
Where?
I initiated my lights and sirens around Piedmont Drive and Thomasville Road.
About how far is that from where you first saw the defendant's truck?
At least several miles.
Why did you initiate this traffic stop?
That occurred, the traffic stop I initiated immediately after he almost sideswiped the car.
Who was driving the truck?
The driver identified himself as Matthew Zaleski.
And do you see him here in this courtroom today?
I do.
If you could point to him and identify him by an article of clothing that he's wearing.
It's the gentleman sitting over there in the blue shirt.
The record could reflect the witnesses identified the defendant. All right. Once you approached the truck, what did you notice about this defendant?
When I approached the truck, I noticed that he had a very strong smell of alcohol coming from his breath. His eyes were glassed over and bloodshot.
Are these indicators of impairment to you?
They are.
Did he make any statements when you first made contact with him?
When I first made contact with him, when I requested that he turn off the car and put the vehicle in park, his first statement to me was, I live just up the road, is there any way we can fix this?
All right, and based on what you had observed up to this point, what did you do next?
I requested that a DUI officer respond to the scene.
And did you request anything else of the defendant?
I requested that he step out of the vehicle.
Okay. Did he have trouble getting out of his vehicle?
He did.
Okay. If you could describe that to the jury.
So when he tried to get out of the vehicle, he fumbled with the door handle for quite a few seconds before he was actually able to open it. As he was stepping out, he stumbled backwards into the driver's seat, and then he was unable to stand without assistance. He had to pretty much lean up against the car the entire time.
I want to shift gears a little bit and ask you, do you have a body camera now?
I do.
Is it kind of on your uniform there?
Yes, sir. It's right here.
All right. Did you have a body camera in September of 2018?
I did not.
Yeah. Did anyone in the Tallahassee Police Department, if you know?
I'm not for sure that they did. I think they were still experimenting at that time.
Okay. When did you get a body camera?
Approximately a year and a half ago.
Did you have an in-car camera at this time?
I did not.
Okay. So after observing all these things and calling Officer Braxton, did that conclude your involvement in this case?
It did.
And everything that we've been talking about this far, in what county did that occur?
Leon County.
No further questions.
Any cross-examination?
Yes, Your Honor. Good afternoon.
Good afternoon.
All right, so you said you've been an officer there for approximately 5 years, is that right?
Yes, sir.
And so you're officer for about 2 years when this happened, is that fair to say?
Yes, sir.
How many DUI arrests have you made in your career so far?
I have never made any DUI arrests. However, I have pulled over multiple vehicles on suspect of DUI, and they were later arrested.
That was, you haven't made any of the arrests yourself, is that fair?
Yes, sir.
Approximately how many other times have you been involved in situations like this, where you pulled someone over and then they were ultimately arrested?
I don't have an exact number, but at least several dozen.
And so, you indicated you didn't have a video that night, right?
Yes, sir.
Paint a picture for us. You are facing, I guess, is that west or kind of northwest?
It's west. Yes, sir.
Due west, okay. So you're facing on Benton, westbound. Are you the first car in the line?
No, sir.
Someone else is in front of you.
Yes, sir.
But you said when all of a sudden you see from your left, Mr. Leslie's vehicle comes into camera, or comes into your view?
Yes, sir.
Left or right? How far does he get out in that intersection?
His back axle was past the stop bar.
Does that
So
mean
the
his
back
car was past the stop bar?
Just the wheels. The bed of his truck was still behind the stop bar.
You said he almost hit a vehicle, right?
He did.
Why didn't she hit your lights then?
Because my positioning wasn't correct in order to initiate a traffic stop.
Is that a policy?
No, sir.
So that's your opinion, that's not a policy. You could have hit your lights, fair to say.
Yes, sir, but the officer's safety would have been compromised by pulling in front of the vehicle with my lights on.
Sure, but I think all of us in this room have been where officers suddenly hit their lights and other vehicles moved out of the way. Is that right? You've seen that happen before.
Yes, sir.
You've done that at a stoplight before, maybe, when you hit your lights?
Yes, sir.
And the vehicle supposedly almost hit another car, and you just let it continue 2 miles down the road.
Yes, sir.
Was it your testimony that eventually when your light turned green, you pulled out and he's still sitting there on Thomasville Road? Is that fair to say?
Yes, sir.
And so you take a right-hand turn and then pull into, is that a bookstore there? I forget what that is.
I think it's a Goodwill.
Goodwill, okay. And so you pull into that parking lot facing northbound?
Yes,
Is that
sir.
fair to say? So you're there where you can easily pull out once Mr. Zaleski pulls past you, right?
I tried to, however, like I said, the traffic was very heavy that night.
But you got behind him, right?
Yes, sir.
You were directly behind him, right?
Not immediately, no.
How long before you were directly behind him?
I wasn't able to catch up to him until Piedmont.
You're saying you didn't see his vehicle until Piedmont?
No, I could plainly see his vehicle, but I was not directly behind him until Piedmont. There were other vehicles in between us.
So his car pulls out from Thomasville and Benton and hits the curb. How long after that?
He hit the curb approximately 3 times.
When's the 1st
I'm
time?
not exactly sure where it was along the way.
May I approach a witness, Your Honor?
Yes, you may.
The counsel in court reference, I'm referencing page 14, line 7. You could go ahead and read this silently when you know when you're ready. Does that refresh your recollection about how long after
Yes, sir, it does.
Benton? And so, what was that?
Approximately 300 feet after I observed his vehicle.
So about a football field after Benton is when he first hit that curb, right?
Yes, sir.
And where were you when you saw that? Out on Thomasville?
Yes, sir, northbound on Thomasville.
And so you're on Thomasville Road, you see a vehicle that almost blew through a light, almost hit another car, and now you see the car going 60 and a 45 and hitting a curb, and you hit your lights, right?
No, sir, not at that time.
Okay. So at this point, he's not a danger to the road at this point.
He was, like I said, my opinion was because of the heavy traffic that if I hit my traffic lights at that time, that he would either flee or end up causing a wreck.
Okay. Approximately how long after that did he hit a curb and almost flip his vehicle?
I don't have an approximate location.
When he almost flipped his vehicle, and after he had gone 60 and a 45 and hit a curb and almost blew through a light and hit somebody, you hit your lights then?
Yes, I did.
I thought it was after he almost hit another car, or was it when he flipped his car?
It
Flipped
was, so when he hit the median and he swerved back over, he almost flipped it, and then that was at the same time that he almost struck the other vehicle.
All right. What was the other traffic doing at this time? I believe you spoke with the state about that.
They were trying to fall behind, which was causing a traffic jam for me to try and catch up.
What happens when you hit your lights?
When I did hit my lights, the traffic immediately moved to the side, with the exception of one car.
All right. With the exception of his car, right? Is that what you're
No,
saying?
sir, there was another car in front of me that was still in my way.
You could have hit your lights much earlier on Thomasville, and the other vehicles would have done the same thing, gotten out of your way to pull him over if he was such a danger to the traffic, correct?
Presumably.
But you chose not to hit your lights until about 2.5, 3 miles down the road?
No, sir.
I'm sorry, I probably asked that poorly worded. You didn't hit your lights until 2.5 or 3 miles down the road?
Yes, I did.
And so these other vehicles are presumably, you said, staying away from him, right? They don't want to go anywhere near him?
After he hit the median and came back over the third time, yeah, they all started falling back.
So they weren't falling back before?
No, sir.
Do you remember telling the state that they were staying away from his vehicle the entire time?
My apologies. It was once he came back over the third time.
And this wasn't at rush hour, right? Where you're saying there's heavy traffic out on Thomasville Road, is that right?
No, sir, no.
This was
There was heavy traffic, but it was not during rush hour.
This was 10:30 p.m.
Yes, sir.
On what day?
I believe it was September the 3rd.
Do you remember what day of the week that was?
No, I do not.
But your testimony is there's so much heavy traffic, 10:30 at night on Thomasville Road to prevent you from pulling this driver over for 2.5 miles. Is that right?
Oh, yes, sir.
You didn't get any calls for service from 911 or that there are concerned drivers out on the road, that there was an impaired driver, is that right?
No, sir.
As an officer with Tallahassee Police Department, you all are equipped with, I guess, mobile data recorders. They basically track where you are and how fast you're going, is that right?
Yes, sir.
Did you go back and get those records to the prosecution to show how fast you were going, to verify how fast he was going?
I did not.
You mentioned with the state that Mr. Zaleski told you that, is there anything I can do to fix this? At that point, you hadn't discussed anything related to a DUI, is that fair to say?
No, I had not.
You hadn't asked him how much he had to drink or where he's coming from or anything like that?
No, I had not.
So it's fair to say that could easily be a response to just getting out of a traffic ticket, is that fair to say?
Possibly, yes.
Did you issue him a traffic citation?
I did not, no.
So despite all of the actions that you told the jury about and testified with the state about, there's no traffic citations?
There is, but I was not the issuing officer.
Well, there's a DUI citation, but there was no traffic citations for any of the actions that you saw, correct?
Oh, no, sir.
Back in, this is 2018, did you have a department-issued cell phone at all? Or a
Don't
personal?
believe we had been issued cell phones at that time yet.
Okay, did you have your personal cell phone?
I did.
And did that have a camera on it?
No, it did not. Well, excuse me, it does, it's just I don't use my personal cell phone for work.
Okay. Nothing further, Your Honor.
Any redirect?
Yes, Judge. Mr. Smith, I just wanted to ask some follow-up questions, some clarification. You indicated that you had pulled into a parking lot. Do you remember which business that was, or if it was a business?
I believe it's the Goodwill business. It's on the northeast side of the intersection.
Okay, all right. And approximately how far was he from you at that point?
He was directly behind me. He was still sitting over the line at the intersection.
And when you pulled back into Thomasville Road, how far down the road was he to you?
He was about 2 or 3 car lengths, but he was going in excessive speed, and there was another car in front of me.
If you can remember, I mean, how many cars were in front of you that night?
At that point, I'd say at least 2 on each side.
Are you allowed to ram into these cars to get them out of your way?
No, I'm not.
What's the way that you try to get them out of your way?
I try to wait until I can have a decent path so I don't strike their vehicle. If that's not available, then I kind of go behind them, and usually they get the hint that they need to move.
And is that for their safety?
Yes, it is.
Nothing further.
All right. Do you plan on recalling this witness?
No, Judge, she's released.
All right, Officer Smith, you can step down and you're released from the stand. Mr. Wade, did you subpoena Officer Smith as well?
No, but we released as well, no objection.
State, you can call your next witness.
State calls Officer Derek Braxton.
You could just let the clerk swear you in, Officer Braxton.
Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
All right, so you can have a seat in the witness chair and make sure you pull yourself up close and speak into that mic. State your name, Inquiry.
Thank you, Judge. Good afternoon, sir. If you could introduce yourself to the jury.
Officer Derek Braxton with the Tallahassee Police Department.
How long have you been with TPD?
16 years?
Do you have any prior LEO experience, or is it just TPD?
No.
All right. What special training do you have in observing and detecting impaired drivers?
Went to the basic field sobriety class. Also ARIDE, which is the Advanced Roadside Impairment class. I'm also a breath test operator, and I'm also a DUI instructor.
What are indicators of impairment?
They are different cognitive and physical and driver patterns, basically, that I take to see if someone's impaired or not.
And can you describe some of those?
There's a lot of them. It could be anything from slurred speech, glassy eyes, swerving in the road, stuff like that.
Have you ever participated in wet labs?
Yes.
What are those?
Wet labs, they're where we have certain people, they drink alcohol of different variations to where we observe them and have them do different field sobriety exercises to where we look at their impairment to test, to put that simply.
How many times have you investigated possibly impaired drivers?
Thousands.
Do you arrest everyone that you suspect of being an impaired driver?
No.
Why not?
Not everybody meets the totality of the circumstances in order to meet the DUI standard.
And how many DUI arrests, if you can approximate it, have you made?
Maybe between 400 and 500.
And you mentioned the totality of the circumstances. When you arrest someone for DUI, is it based on one thing?
No.
And what is it based on?
It's based on the totality. I look at everything from the driving pattern into me making contact with the driver, and also their cognitive skills when I'm talking to them, and their physical impairments if they have any.
All right, now, Officer Braxton, I'd like to shift gears a little bit. Talk about this case. How did you become involved in this case?
Officer Smith called me to the scene.
You remember what date that was?
September 3rd, 2018.
About what time did you get involved in this case?
I think it's approximately a little after 10:20 p.m.
And where was that?
at Thomasville Road and Raymondale Road.
And did you ever come into contact with this defendant?
Yes.
What did you see when you first came into contact? contact with him?
When I first exited the vehicle, he was leaning on the back of his truck.
Did you notice any indicators of impairment at first contact?
Yes.
And can you describe those?
First contact, other than leaning on the vehicle, which is something that we take into account as well. He was swaying in place. He was also swaying while he walked. That's the initial before I started talking to him.
Could you smell anything on him?
Yes.
And what was that?
I could smell a strong odor of an alcoholic beverage coming from his breath.
Did you talk to the defendant?
Yes.
Did he tell you where he had been?
He said he went to Midtown Caboose.
Did he say if he had been drinking?
Yes, he did.
And how much did he say it had to be?
At first he said not too many. Of course, then, I asked again, and he said he had 1 or 2 drinks. Then he clarified and said 1 or 2 beers.
During the conversation, you may have already said it, did you notice anything about his speech?
Slurred, slightly slurred, that I indicated.
And after observing all of that and the indicators of impairment that you saw, at some point did you make a decision to arrest this defendant?
Yes,
What was it?
a DUI.
Where did you transport the defendant after?
To Leon County Jail.
What is a breath test?
A breath test is something we use. We use an intoxilizer to measure the breath alcohol content by taking their breath.
And how is it collected?
Through the intoxilizer at 8,000.
In September of 2018, did you have the ability, or did you have the ability to perform a breath test roadside from your car?
I didn't know.
Did anyone in TPD?
I think at that time in 2018, I think we had 1 person that was able to. I don't know if he was working at night or not.
Where are these breath tests normally performed?
At the jail?
And is that where you took this defendant?
Yes.
All right. When you got to the jail, did you request a breath sample from this defendant?
Yes, I did.
And what was his answer?
His initial answer was not if I don't have an attorney present or something to that effect.
What is implied consent?
Implied consent, it's basically what we all have on the back of our license. We have implied consent to take a breath test is part of the thing that we have to get a driver's license. It's saying that you'll submit to the breath test if asked by a police officer during an investigation of a DUI.
Did you read implied consent to this defendant?
Yes, I did.
Is that memorialized in writing anywhere?
Yes.
Your Honor, this time I'm opposing counsel to what's been pre-marked as State's Exhibit 1.
No objection, Your Honor.
Your Honor, this time I move into evidence what's been pre-marked as State's Exhibit 1 as Exhibit 1.
All right, moved in without objection?
Permission to approach?
Yes.
Officer Braxton, what is that?
See implied consent warning.
Is that
I
the
gave
implied
for.
consent form that you read to the defendant that night?
Yes.
Okay. If you could read it from the top, exactly what you read the defendant.
It's the implied consent warning, now requesting that you submit to an approved test of your breath for the purpose of determining the alcoholic content of your breath.
And after you read that, what did the defendant say?
Not without my attorney present.
All right. What's your next move after that?
I read the second part. If they initially refuse, do you want to go and read that also?
Yes, sir.
If you fail to submit to the test I have requested of you, your privilege to operate a motor vehicle will be suspended for a period of 1 year for a first refusal, or 18 months if your privilege has been previously suspended as a result of refusal to submit to a lawful test of your breath, urine, or blood. Additionally, if you refuse to submit to the test I have requested of you, and if your driving privilege has been previously suspended for a prior refusal to submit to a lawful test of your breath, urine, or blood, you will be committing a misdemeanor per Florida Statute 316.1939. Refusal to submit to the test I have requested is admissible into evidence into any criminal proceeding. Do you still refuse to submit to this test, knowing that your driving privilege will be suspended for a period of at least 1 year, and that you may be charged criminally for any subsequent refusals?
Okay. And what was the defendant's answer after you read that last portion?
It was still yes, as in he's still not going to take the breath test.
And did he sign the form?
Yes.
Your Honor, permission to retrieve?
Yes.
Officer Braxton, in September of 2018, did you have a vehicle-mounted camera on your car?
Yes,
Okay. Was it working?
yes.
Was your interaction with this defendant caught on camera?
The audio part,
The audio, okay. Can you hear the defendant in this video?
yes,
And did that capture the audio of your interaction with him pretty much the whole time that you were talking to him?
yes, it did.
All right, now approaching the counsel with what's been remarked to State's Exhibit 2.
Yes, Your Honor, I reviewed this, no objection from the defense either.
And at this time, Judge, I move in evidence what's pre-marked to State's Exhibit 2 as State's Exhibit 2.
Enter into evidence without objection.
Permission to publish.
Permission granted.
You can have the instruction again.
Members of the jury, you are about to view a video recording. The court instructs you that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way you view and consider this evidence.
Anything
Now, question is submitted to a food test of the person determining the alcohol content. What do you think there? I'm not doing that on the surface. I'm not doing that. Not on the surface. I know you're trying to have nothing to do with this part, right? Alright, Sarah Smith is tested on questioning your purpose to operate a motor vehicle suspended for a period of 1 year for your first refusal or 18 months and Sarah which has been suspended as a result of refusal to make a long test in regular or blood. Additionally, if you refuse to make this test, I will question you and God's privilege has continued to the court, previously suspended for final refusal to make a long test in regular or blood, you can make a misdemeanor. If you submit the test I have requested is admissible into evidence of any criminal proceeding. You still refuse to make this test, knowing that your driving privilege will be suspended for a period of at least 1 year and may be charged criminally for subsequent refusal. Yes, I need to record.
All right, Officer Braxton, based on your observations, training, and experience, did this defendant show signs of impairment?
Yes.
Was it just one indicator?
No.
What were those indicators?
It was the leaning on the car, bloodshot eyes, droopy eyes, glassy eyes, blank stare on his face, the swaying in place, the swaying while he walked, the slurred speech. I believe that's all of them. I might be missing one or two, but
Was the smell present?
yes, and the strong odor of an alcoholic beverage. Yes.
And everything we've been talking about today, did that occur here in Leon County?
Yes.
Okay. Nothing further, Judge.
All right. Any cross-examination?
Yes, sure. No, sir.
Afternoon.
You mentioned some training that you've had in DUI detection, DUI enforcement with the state, right?
Yes.
One of those courses was A-RIDE. You called it advanced. It's Advanced Roadside Impaired Driving Enforcement, right?
Correct.
And that mainly deals with drug driving, a lot of that curriculum, is that right?
Yes, it's an extension. And it focuses on drugs also.
Okay. All the other training you've had, you went over some wet labs, all of that training is training you to make a decision to arrest someone based on probable cause, right?
Correct.
And the training's not designed for you to make decisions based on beyond a reasonable doubt what the jury has, right?
Correct.
You're just there to make a determination on probable cause, whether you have enough to arrest them, right?
Correct.
Okay. The DUI detection
an enforcement class you've been to, and I believe you said you may even you teach field sobriety exercises also.
Yes.
It's a 24-hour course, right? Broken up into 8-hour days?
Yes, the basic one, yes.
It teaches you how the phases are, there's 3 different phases in your DUI investigation, is that right?
Yes.
First phase is vehicle in motion.
Yes.
And you didn't observe phase 1, that was Officer Smith, is that right?
Correct.
Talk a little bit about, I guess I don't know if there's any policies from TPD, but how do you pull someone over? How are you taught to pull someone over when you see a traffic infraction?
How do you pull somebody over?
Right.
After you see a violation, you turn on your emergency lights and pull them over into the safest spot on the side of the road.
Okay. And the intent there is once you see that violation to hit your lights immediately so to protect the public, is that right?
Yes.
Okay. There's nothing in the training that says, you know, after you see a violation, wait 3 miles down the road to hit your lights, right?
No, not that I know of.
You came into this investigation during phase 2, the personal contact phase, is that right?
Yes.
And one of the things you said that you smelled that night was a strong odor of alcohol, is that fair to say?
Yes.
Would it also be fair to say that the odor of alcohol, you can't tell how much someone drank just by the odor on their breath?
No.
Would you agree that the odor of alcohol doesn't indicate whether someone is impaired, just rather whether someone consumed the alcohol?
Correct.
Okay. Now, you also talked with the state about the swaying on his feet and the swaying while walking, is that right?
Yes.
During your interaction with Mr. Zaleski, when you saw him walk from his car or truck over to you, and then when you walked from wherever that was to your vehicle after you arrested him, he was never staggering on his feet or stumbling, is that right?
At what point?
At any point during the investigation, he wasn't staggering or stumbling, is that fair to say?
At the beginning, yes, when I made my personal contact with him. If you're talking about the third part, because you went over 3 different parts, if you're talking about the third part where he was walking in handcuffs over to my car, my hand was on his arm. So he wouldn't have been staggering at that point.
Do you remember the testimony with the state a few minutes ago?
Yes.
And there was no staggering on his feet at any point. You said he was swaying, is that right?
When he walked from his back of his truck, that's when I was watching him walk.
And that's when you said he was unsteady on his feet?
Yes.
Do you remember writing a report in this case?
Yes, I do.
And did you include all of your observations related to impairment in the report?
Yes, I did.
May I approach a witness, Your Honor? If you want to review that, the report and let me know when you're done.
I'm good.
You stated you had included everything, but it would be fair to say you didn't include anything about staggering or stumbling as he walked from the vehicle, is that right?
It's right here on the second line.
And what did you say? He was swaying?
Zaleski was swaying as he walked.
So again, getting to what I was getting at, that you said he swayed while he walked, but there was no staggering or stumbling as he walked.
Okay. No staggering or stumbling, no.
Okay. All right.
Sorry, I misunderstood.
Making sure we're getting on the same page.
Oh, gotcha.
All right. And you can keep that. You're taught that whether someone's staggering or stumbling, that could be an indicator that someone's impaired by alcohol, right? Another indicator that could be a sign someone's impaired by alcohol is whether or not they have a flushed face or not. Is that also?
Yes, that's one.
And you didn't see that on Mr. Zaleski that night?
No.
An indicator of impairment you're taught to look for is also someone being loud or abusive towards you or profane or argumentative. That can be a sign they're impaired by alcohol.
Yes, those are several also.
And you didn't observe that in this case, is that right?
No.
At all times he was polite and cooperative with you?
Yes.
It can be a sign they're impaired by alcohol if there's any open containers in the vehicle. Is that also true?
Yes.
And you didn't observe any open containers, is that?
No.
Cover-up items items can be an indicator someone's impaired when they're popping in gum in their mouth or smoking a cigarette or spraying cologne to try to mask any odors. That can be a sign that they're impaired. Is that also true?
Yes.
You didn't notice that in this case, correct?
No.
You mentioned Mr. Zaleski was leaning on his truck when you got on scene, correct?
Yes.
Do you know how long he had been out on the side of the road outside his truck?
No.
So you can't tell the jury whether or not that was due to him just waiting for a period of time or whether he was impaired? Is that fair to say?
Yes, sir.
You also mentioned he was like swaying when he was walking. You hadn't met Mr. Zaleski before, is that fair to say?
No, I haven't.
You don't know how he normally walks, is that right?
No, I don't.
You didn't get to ask him any questions about his injury history or any abnormalities he may have, is that fair to say?
Never got to that part.
I guess would it be fair to say, not knowing Mr. Zaleski before, you don't know what normal is for him? Is that fair to say?
Yes, sir.
You eventually discovered, and he told you that he was coming from Midtown Caboose. Is that right?
Yes.
Did you have Officer Smith or any other officers go back to Midtown Caboose to talk with any of the staff at all?
No.
Did you all gather any receipts from that business at all?
No, we didn't.
And then we saw, and you talked with the state about it, the breath test at the jail, is that right?
Yes.
Is it common for people when you say that implied consent warning, some people go, hey, what's that? Like, not everyone knows exactly what's on that sheet before?
Well, that's common. Some people do ask.
Okay. And you've dealt with people in the past that may think they have a right to an attorney and want to ask for an attorney at that point, is that right?
Yes.
And that's what Mr. Zaleski did at this point, is that right?
Yes.
And you told him that he didn't have couldn't speak to an attorney right now unless he can get him on the phone, is that right?
Right.
But he does have a right to decline the breath test, is that right?
Yes, he does.
And we saw he eventually exercised his right to decline that test when he was in the Sallyport handcuffed in the jail, right?
Yes.
Even if he had blown .07, just under the legal limit, he's still under arrest at that point and going to be booked on a DUI. And is that right?
Yes.
So no matter what he blew, he was already arrested, going to be booked for the DUI charge that you arrested him for.
Yes.
One moment, Your Honor. Nothing further, Your Honor.
Any redirect?
Yes, Judge. Officer Braxton, opposing counsel asked you a little bit about safety. When you hit your lights, you do so immediately. If there are cars between you and the car that you're trying to pull over, is it fair to say you might not immediately hit your lights?
Yes.
Okay. You were asked, about what indicators that there weren't. Have you ever investigated anyone that's ever displayed every indicator of impairment?
No.
Is that improbable?
Objection, relevance, and proper opinion testimony. Overruled.
You can answer.
Yeah, that's kind of hard to do. It's a lot of indicators in order for one person to display all of them.
And while he didn't have open containers in his car, he had admitted to drinking, hadn't he?
Yes.
You were asked about gathering receipts at Midtown Caboose. Is that something that you normally do?
No.
Okay. And after you booked him, about how long was this after your first encounter with him? Got him booked in the jail and when you left, do you remember?
I know he was arrested at 10:30 and made my way to the jail. Read and complied consent at with 10:53, so this is what, maybe 22, 23 minutes after.
Yes, sir. All right. All right. And you were asked a little bit about him, saying when you were reading the implied consent, like an attorney. So even after you told him that he couldn't have an attorney at that point, did he still keep insisting on it?
Yes.
Nothing further, Judge.
Does this witness need to be retained?
No, Judge. He's excused.
No objection.
All right, you're excused from your subpoena. You can step down.
Thanks, sir.
State, you can call your next witness.
Your Honor, this time the state rests.
Ladies and gentlemen of the jury, this is a time when we're going to need to take a break and handle some stuff outside of the presence of the jury. So if you could please go with the bailiff, she will take you back. Remember to not discuss the facts of the case amongst yourselves or with anybody else. And we will call you back in a few minutes. Thank you. Okay, the jury is outside of the courtroom. The state having rested. At the defense, do you have any motions?
No motions, Judge. We won't have any evidence either.
All right. So are you ready to rest on the record?
Yes, Your Honor.
Let's see, it is 2:25. Let's take a break. Be back here in 10 minutes, so around 2:35.
Yes, Judge. Is that when we'll do the charge conference and
Yeah.
jury instructions? Yeah.
We'll do that, and then we'll bring them back in and do all that.
Yes, sir.
Open session.
Have you seated? Let's take a look at the jury instructions. I know that you all agreed to these prior, correct?
Yes, sir.
Yes, Your Honor, I believe they're from that previous trial.
So did we, Ms. Rissinger, after we put them in our format, did we send them back to them? All right, let's just go section by section. All we did was reformat, so I just want to make sure that there are no changes. So 3.1, 3.2, those are standard. 28.1, are there any changes to that one?
Nothing from the state, Judge.
Nothing from the defense, Judge. May remain seated?
Yes. 3.7 is standard. 3.9, also standard. So we need to take out defendant testifying, is that correct?
Yes, Your Honor.
Still decide not to testify. It's your decision, so just making sure.
And Mr. Zaleski, I just want to go ahead and put this on the record now, since your attorney has indicated that he does not intend to call you as a witness. You had an opportunity to sit and talk to your attorney about this, and I'm sure you had some previous discussions about testifying. A lot of the decisions that are made during trial are decisions that are made by your attorney, but the decision whether to testify or not is solely up to you. Have you had adequate time to talk to your attorney about whether you wish to testify or not?
Yes, Your Honor.
And after those conversations, do you wish to testify?
No, Your Honor.
Okay. All right, thank you, sir. So we will leave in 39A, which is defendant not testifying. 310, rules for deliberation is standard. 311, the cautionary instruction. 3.12, 2.7, 3.13. I don't think there's anything else that needs to be changed. Is that correct?
Everything else looks agreeable, Judge.
Yes, Your Honor. Acceptable to the defense.
And did y'all also get the verdict form, Judge?
We did. And that verdict form looks good. Is it acceptable to the defense?
Yes, Your Honor.
Acceptable to the state?
Yes, Judge.
All right, so Ms. Rissinger, if you could please take out defendant testifying. And then we need 10 copies of the jury instructions. And just 4 copies of the verdict form. Just give one each counsel, one for me and then one for the foreman. All right. Yes, we can take a brief recess until Ms. Rissinger is back with the jury instructions.
Stress the shit. Stress the shit. Understand. Watching the video. Yeah. If you were sitting in the jury, I would like to ask for a fine say. Sometimes we in the legal field think of all this shit, but we're in the legal something to talk about. Yeah, I don't think anything that's supposed to be really definitely anything wrong. If you don't say one thing, what would you definitely hit? Well, I mean, I can't spell it. Like, it conflicts with what we were saying. Yeah. The guy that's somebody in the back, coming back into the car, and get out of the car. Yeah, they're not holding you. Right. The fact it is really you have to go beyond. I never tried to tie to lie that. Yeah. It's tired. It's like hell outside. Yeah, I saw there was something separating or something like that. Have you seen? I haven't even gone outside. No, I just went to the bathroom. I looked out the window. Time. It's like I saw from like 12 to 8. This was like 70% chance of rain. So it's pretty good for. I guess Lake Jackson's filling back up. I don't know if you saw where it like emptied out. Yeah, I saw pictures. I didn't go out. I wish I would, but apparently it got water in it now. It doesn't rain for the past week, but wish I would have it. But the pictures look pretty cool. Yeah, it looked like a moon. Right. I saw they found like a seat from a John boat, like just a pole, and then the seat hoops down. There's no boat, just someone got angry at the seat, I guess. When I get home, I'll take it now. Yeah. Crazy. They're running like crazy on jury selection. Once that coffee kicked in, good man. What's all that? The closing statements. Doesn't it? So they deliberate. They went to it, and then they come back and say the verdict. So the state will get to go. I go. And the state gets to go. But they get kind of a sandwich closing, where if the person who asked for it since dead before that's up. The legal system puts it in a car crash case. The person who was in the accident has the burden, so they get the first and last for that. Okay, like the other 2000, no evidence. we would get early 2000, we would get a lot for it right now. Yeah, but got rid of that because it was crazy. Huge Mexican attorney for like, imagine doing that rich shit. Okay, we have a really good witness that we want to testify. But now we would have to make that call shit. We've got that witness that we get the last quote. So it costs a lot of people. A lot of days more than that is not to put on. So what are good for clients to have to make that call?
Yeah.
And defense attorney.
If my parents ask me, I'm like, no, I don't.
No, they stopped that.
Yeah.
Yeah, nobody had said anything, so I had, I pulled up the case.
Yeah. Yeah.
I don't know why they don't keep it. The Pinellas and some other county, they do every single courtroom. You can just log into a courtroom and see what's going on.
All right, court's back in session.
You guys. All right, please take a chance to look at these instructions and in the jury verdict form to just make sure that no changes were made. Both sides had an opportunity to review the instructions.
Yes, Your Honor, no
Yes, sir.
objection.
And the verdict form is acceptable.
Yes, Judge.
I don't think we made any changes to that. All right, let's bring, my plan is to bring in the jury, let the defense rest on the record, and then I'm just going to roll in the final jury instructions. Is that okay with both parties?
Yes, sir.
Yes, Your Honor.
Okay.
All right, jury entering the courtroom.
You may be seated. All right, defense, we call your first witness.
We'll rest as well, Your Honor.
All right, ladies and gentlemen, the defense has rested, so now it's time for the final jury instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Mr. Zaleski, the defendant in this case, has been accused of driving under the influence. To prove the crime of driving under the influence, the state must prove the following two elements beyond a reasonable doubt. Mr. Zaleski drove a vehicle, and while driving the vehicle, Mr. Zaleski was under the influence of an alcoholic beverage to the extent that his normal faculties were impaired. Normal faculties include, but are not limited to, the ability to see, hear, walk, talk, judge distances, drive an automobile, make judgments, act in emergencies, and in general to normally perform the many mental and physical acts of our daily lives. Impaired means diminished in some material respect. Alcoholic beverages are considered to be substances of any kind and description which contain alcohol. Mr. Zaleski has entered a plea of not guilty. This means you must presume or believe Mr. Zaleski is innocent. The presumption stays with Mr. Zaleski as to each material allegation and the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome Mr. Zaleski's presumption of innocence, the state has the burden of proving the crime with which he is charged was committed, and he is the person who committed the crime. Mr. Zaleski is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find Mr. Zaleski not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of Mr. Zaleski may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find Mr. Zaleski not guilty. If you have no reasonable doubt, you should find Mr. Zaleski guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. You may rely on your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for Mr. Zaleski to disprove anything, nor is Mr. Zaleski required to prove his innocence. It is up to the state to prove his guilt by evidence. Mr. Zaleski exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that he did or did not take the witness stand to give testimony in this case. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending on you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if Mr. Zaleski has been proven guilty or not, in accord with the law. It is the judge's job to determine a proper sentence if he is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I prefer one verdict over the other. You may find Mr. Zaleski guilty as charged or not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. So one of you, when you're a selected foreman, will get this verdict form when you go back. It reads, in the county of the 2nd Judicial Circuit in and for Leon County, State of Florida versus Matthew Zaleski defendant, case number 2018 CT 1871. Verdict. We, the jury, find as follows as to count 1, driving under the influence. A, the defendant is guilty. B, the defendant is not guilty. You only check one box. So say we all this blank day of June 2021, signed by the foreman. So it is the foreman's responsibility to check one of the boxes, date, and sign it. Both the state and Mr. Zaleski have now rested their case. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instructions on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing arguments. State.
Thank you, Your Honor. May it please the court, opposing counsel, members of the jury, good afternoon. First thing I want to do is I want to thank y'all for your time and your attention up to this point. I know it's been probably felt like a long day, but we really do appreciate your patience throughout this process. This case started with the defendant speeding down the road and driving all over the road on September 3rd, 2018, and now it concludes in your hands. So how did we get here? Well, on September 3rd, 2018, Officer Smith told us that she was on uniform patrol when she observed this defendant in his car enter the intersection of Benton and Thomasville Road, past the stop bar, almost striking another vehicle. Officer Smith told us that as soon as the light changed, that car sped off on north on Thomasville Road at a high rate of speed. She told us that she entered that parking lot, the Goodwill parking lot, and started to follow. She did this to start observing signs of impairment. And as she told us, the defendant's car was going about 60 in the 45. During this time, his truck was weaving all over the road, striking the median multiple times and coming back into his lane. One time swerving back so hard that he almost struck the car next to him. When she was finally able to catch up to him near I-10, she initiated that traffic stop, and she told us what she saw when she first made contact with this defendant. She noted the strong odor of alcohol. His eyes were glassy, bloodshot. First thing he said as I lived just up the road, "Is there anything I can do to fix this?" After observing all these things, she told us that she asked him to step out. She told us that he fumbled with the door handle, had a problem getting out, stumbled back into his seat, and had to lean on his truck for balance. You heard that after observing all of this, she called for backup. That's when Officer Braxton arrived, and he told us what he saw that night. When he arrived, the defendant was leaning on his truck. He had a noted sweat. Speech was slightly slurred. There was a blank stare on his face. Eyes were bloodshot and glassy. Strong odor of alcohol. You heard him tell Officer Braxton where he had been. Y'all could hear that on the video. Midtown Caboose. Had not too many. And he changed his story from one or two. It clarified it was beer. You heard that based on his observations up to that point, Officer Braxton made a decision to arrest this defendant for driving under the influence. At the jail, the defendant was asked to provide a lawful sample of his breath, and he refused. He was explained the consequences of that his license would be suspended for at least a year if he refused, and he gave up his privilege to drive for a year by still refusing to do so. So what does all this mean and why are we here? Well, today we had the burden of proof to prove each of these elements to you beyond a reasonable doubt. One, that the defendant, Matthew Zaleski, drove a vehicle, and that while driving the vehicle, he was under the influence of alcoholic beverages to the extent that his normal faculties were impaired. Now, I don't think element one is really contested. He was driving the vehicle beyond a reasonable doubt. So, you were to find normal faculties. That's defined for you. Include but are not limited to the ability to see, hear, walk, talk, judge distances, drive an automobile, make judgments, act in emergencies, and in general, to normally perform the many mental and physical acts of our daily lives. Now, definition of impaired means diminished in some material respect. Well, let's think about that. Normal faculties impaired. I would submit to you that driving your car all over the road, swerving back and forth, striking the median, almost hitting other cars, I submit to you that that is impaired, diminished in some material respect, his ability to drive a car. So what are the other indicators that we have? Well, again, we have that strong odor of alcohol. Of course, that in and of itself doesn't mean anything, but it's coming from his breath. And of course, he admitted to drinking. We know that he was drinking. He said not too many, then he said one or two. I don't have to prove to you how many he had. I have to prove to you that however much he had, it impaired his normal faculties. He had trouble on his feet. He was using his truck for balance. I ask that you consider all of these things together. His driving pattern, the testimony of these officers that you heard, the odor of alcohol, the slurred speech, and his refusal to submit to the breath test. When you consider all of those things, I'm asking you to return a verdict of guilty for driving under the influence.
Defense?
It's up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You should use your common sense. There's an eighth juror that I like to talk about that'll be standing at the door of that verdict room saying you can't come out until I've been completely obliterated, and that's the presumption of innocence. You read a little bit about the presumption of innocence and jury selection. We talked a little bit about it. And I believe after hearing the testimony about what happened, as the judge said, you can base your verdict on a conflict in the evidence. You now have a conflict in the evidence and your own common sense about what took place when Mr. Zaleski was being pulled over by this officer. If it was as bad as she described it today, she would have hit her lights much sooner. I hope you picked up on all of the intricacies in her testimony that should call into question whether all of that happened the exact way she described it or could have happened the exact way she described described it. Again, you have an officer who sees a vehicle go past the stop bar and almost hit someone and didn't hit the lights. Apparently, only a football field down the road before that Shell and that Sun's Trust, he hit a curb going 60 and a 45, presumably, and still didn't hit her lights to pull over. The state just said something interesting. It's finally able to catch up. Finally able to catch up with Mr. Zaleski. When Officer Smith finally was able to catch up with Mr. Zaleski, that's when she hit her lights. What did you hear her say? You heard her say that when the light turned green, she pulled out and pulled into the Goodwill there, and then pulled in behind him after he went past. And did you catch the distance, she said? She said when she pulled out, she was about 2 to 3 car lengths behind him, and there was only one car in between them. So she's telling you that she was only 2 to 3 car lengths behind this vehicle, and it took 2.5 miles to presumably catch up. Again, this does not match up with common sense. You should use your common sense in deciding which is the best evidence. Mr. Zaleski doing 60 and a 45? All right, well, you say there's a vehicle in between you. Is that vehicle also doing 60 and a 45? That's dangerous too. If it was as bad as it was described, these lights would have been hit much sooner than 2.5 miles down the road, almost near the underpass of I-10 and Thomasville Road. She tried to say that this was because for his safety, that she waited that long. When the judge talked with you about beyond a reasonable doubt, and in the instructions that were just read to you, it said the doubt cannot be forced, imaginative, speculative. Nothing's being forced and imagined or speculative. You heard from Officer Braxton, the more experienced officer who's done thousands of investigations. He said that when you see a violation, you're supposed to pull the person over. There's no safety reason to wait to pull someone over if you see a traffic violation. In this case, her lights weren't hit for 2.5 miles because it presumably wasn't as bad as we're being led to believe today. Also, what's interesting is that she never cited Mr. Zaleski for a single traffic infraction. Not a single one. The conflicts in this evidence and the conflicts between the evidence and your own common sense would lead you to a not guilty verdict right there. Again, because you should use your common sense in deciding which is the best evidence. So when the state says, oh, we live up the road, you can fix this, I'm sure they'll talk about that in their final closing. The state gets to speak with you again after I finish. They'll say, oh, well, you said to Officer Smith, hey, I live down the road. Can we fix this? Put that in context. What's that 8th juror doing, that presumption of innocence is doing? Is telling you that, well, that was before a DUI had even been talked about. They weren't even discussing odor of alcohol, where he'd been, what he'd been drinking, anything. Just the reason for the stop. Sure, maybe Mr. Zaleski was flying down the road. But if he was about to flip his car or hit another vehicle, she would have hit her lights much sooner. Again, the reasonable doubt cannot be forced, speculative, imaginative. The state in their opening statement made sure to reiterate that it can't be speculative, imaginative. Nothing is imaginative or speculative about that. Officer Smith told you herself. When I asked her, hey, do you think that he could have been talking about just a traffic ticket? And what did she say? She said, sure. Yeah, that's fair to say. Again, that's a reasonable doubt because the officer even said it herself. The state just talked about him leaning up against his truck and added in that part, using the car for balance. Now, what's speculative imaginable force? Saying that he's leaning on the car for his own balance. That's speculative. No one asked him why he was leaning on his car. What's not speculative, what's not forced, is the questions that I asked Officer Braxton. Officer Braxton, you have no idea how long Mr. Zaleski had been out on the side of that road. You had no idea. You can't tell this jury whether or not that was due to him just being out there for a while and just leaning on the back of his truck, or due to alcohol. Fair to say? And what did he say? Yeah. Again, not speculative, imaginary, or forced. Reasonable, that even the officer agreed with. The state is being speculative by telling you that he leaned on his truck for his own balance. Yes, again, there's an odor of alcohol, and he admitted to drinking. We've talked about that in jury selection, where it's not a crime to have drinks at a restaurant, a couple of drinks, and then get behind the wheel of a car if it's been a sufficient amount of time and you're not impaired. So, Officer Braxton, that odor of alcohol you smelled on his breath, that doesn't mean he's impaired by that alcohol. Fair to say? Yeah. Again, it's not speculative or imaginative or forced. It's agreed to by the arresting officer in the case. You know, the state went through the training that Officer Braxton had. And he's taught courses. He's done many DUI arrests, many DUI investigations. But remember the context in that. That eighth juror, that presumption of innocence, is telling you in your ear. Just because he has all that training and has made all those arrests, that doesn't mean that that training substitutes for your own common sense, for your own decision. Because I asked Officer Braxton, all that training is designed for you to develop enough probable cause to arrest, correct? Correct. So even Officer Braxton, again himself, not speculative or imaginative or forced, he even told you that his training is designed to decide on probable cause, not your decision here today. There were a few conflicts in the evidence where initially the Officer Braxton said that he was staggering while he's walking, and then had to show the report that no, there was no staggering, just, I guess, swaying while walking. But again, you're here to decide whether Mr. Zaleski's normal faculties were impaired. Whether his normal faculties were impaired. And when I asked Officer Braxton, hey, do you know how he normally walks? No. He doesn't know what's normal for him. So he can't say whether that's normally how he walks, if there was any sway. We got to see on camera, he didn't see any swaying as he walked. Interestingly, in this case, is that the state's asking you to base your verdict off of everything that was seen off camera. And then magically, when he's on camera, he's having an intelligent conversation with the officer, not slurring, walking fine. That, again, eighth juror should be calling out to you to use your common sense in deciding which is the best evidence, the one we're being told or the one we can see with our own eyes. As I stated, the judge stated you can find your reasonable doubt in the evidence, conflict of evidence, or the lack of evidence. The lack of evidence of them not bringing him in front of the camera when they were questioning him. So you, the jury, so we could see how he looked when they're describing all of these actions that they want you to base your guilty verdict on, to say he was impaired. You don't get to see him. You say you're going so fast and you're driving so recklessly. Well, you actually, in your vehicle is GPS. You know how fast you're going. You know where you are on the road. Let us see that. Nope. You don't get to see that either. Prove to us what you say is true, state. And they didn't. Don't get to see any receipts from Midtown Caboose or talk to any of the staff. Why? Because they didn't investigate. What, do you normally do that, the state said? No. There's nothing in this jury instruction about beyond a reasonable doubt that said if an officer doesn't normally do something, it can be an excuse. No. It says, in this country, in order to be labeled a criminal, in order to be convicted of something, you have to be convicted beyond a reasonable doubt. There must be proof beyond a reasonable doubt. One of the highest burdens in our justice system. We talked about that in jury selection just a few hours ago, and why it's that high, and why it should be that high. And yes, he declined to give a breath test. He exercised his right, again, as a citizen, to say, no, I'm in handcuffs, I'm already at the jail, I'm no longer cooperating. Every time the state gets back up here and starts talking about the kid with red paint on their hands, why they wouldn't show it to you, we're not resolving a conflict between two kids. We're deciding whether or not someone should be labeled a criminal for the rest of their lives. In here, there's different rules. Interestingly, you got to see his hands behind his back when they were handcuffed. And at that point is when he was asked to do a breath test. Oh, you could have done one on scene with somebody at the police department. Might have one in their car, but not sure if they were out that night. Again, not sure from the state's own witness. How we act in a courtroom is different than how we resolve problems outside the courtroom. And people occasionally listen to people who have been around that circumstance before. In jury selection, it was freezing in that courtroom. And at the end of jury selection, the judge talked about how we never know how cold it's going to be in certain courtrooms, and so you may want to bring a jacket. I noticed, someone wearing a jacket, maybe dressed in some layers, didn't know how cold it was going to be in this courtroom. You didn't know. You didn't know. But you trust someone who's been in that situation before. May not have known what you would have blown, but you trusted someone who'd been in that position before, who'd been around that circumstance before. And what did you hear? Again, put the declination in context. Put his decline to give him a breath sample in context. He said, just give me an attorney. Let me talk to an attorney. What's implied consent? What is that? Now, a lot of, sure, us that have been around the system and know about implied consent warnings and can rattle them off like this, but the citizens may not. You may not know what all of that is they're reading through. You may want to speak to an attorney because you've heard on TV and you've seen where you can ask for an attorney. And when an officer tells you you can't speak to an attorney, and say, no, I'm already under arrest. And what did that officer tell you? No matter if he blew .07 just under, didn't matter what he blew, he was already under arrest, going to be facing the DUI charge. With a verdict of not guilty, you're not disapproving of the cops. And you're not approving of Mr. Zaleski. You're simply saying, state, that's not enough. Not enough for a criminal conviction in this country. Now, this is the toughest part of the trial. As you may have seen, I like to hear myself talk a bunch. And as I kind of hinted at, the state gets to go first, I go second, and now the state gets to go first. So once I sit down, no one else can speak for Mr. Zaleski, except that eighth juror, except that presumption of innocence. That every time they get up here and say, find him guilty because of this, listen to that eighth juror, listen to that presumption of innocence. The last thing the judge will tell you. Maybe not. Yeah. In closing, let me remind you, it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. In this country, the number 1 rule is that for a criminal conviction, you must be proven with evidence all the way up that ladder. And in this case, your common sense is telling you The conflicts in the evidence are telling you, the lack of evidence is telling you that the 8th juror will be standing at that door telling you, you must find Mr. Zaleski not guilty. Because no juror has the right to violate the rules we all share, and it must be done with proof beyond a reasonable doubt. It wasn't. Find him not guilty. I must go home. Thank you.
Mr. Edwards?
Is there anything I can do to fix this? I live right up the road. This is the first thing that this defendant asks Officer Smith. Defense counsel wants you to think about the context. He wants you to think about that this is nothing more than in trying to get out of a traffic ticket. Well, please think of it in the context. Right? It's 10:30 at night. He had been drinking. He knows this officer had just seen him driving all over the road. First thing he says, I live right up the road. I'm almost home. Is there anything I can do to fix this? If that's not evidence of impairment that he knew that he's caught, then I don't know what is. Please use your common sense. Please use your common sense. You're allowed to do that, and I implore you to. As the judge instructed, this is not about the quantity of evidence, the number of witnesses called, the number of exhibits we have for you. It is about the quality of that evidence. You heard testimony of these two officers. Both of them are telling you, yes, strong odor of alcohol. Yes, he's unsteady on his feet. Yes, bloodshot, glassy, watery eyes. All indicators of impairment. When you take them together, when you think about the context of all of this, the fact that he was at a bar, the fact that he had admitted to drinking, and I'm going to talk about that a little bit later, these are pieces of evidence. Standard is beyond a reasonable doubt. It's the same burden we use for all our criminal cases. It's not one that we made up today. Now, the instruction about weighing the evidence. The things that you can consider. There are 6 things that it lists, and y'all can read those. I'm not going to read them again, but one of the most important things in there, to me, is that you get to decide who to believe. You get to decide what to believe. There is no 8th juror. There are 7 of you. Y'all decide. Not me. I don't get to tell you who to believe. Defense counsel doesn't get to tell you who to believe. Judge doesn't get to tell you who to believe. You decide. Officer Smith explained her pursuit of this defendant. The defense counsel says it's a conflict in the evidence. I submit to you that there's no conflict here. I mean, she sees this car almost strike another vehicle. She's following in behind him. In her opinion, it was not safe for her to initiate a traffic stop at that time. That is not a conflict in the evidence. It is evidence. Everything that she testified to is what she observed that night. Again, I would point you to you getting to decide the credibility of the witnesses. In order for you to disbelieve that, you would have to believe that she's lying. I submit to you that she gave you no reason to think so. But even if you don't believe it, the driving pattern, that goes out the window. That's not the only evidence of impairment that we have. Again, 2 people saying that they smell alcohol. Strong odor coming from his breath. Not only that, he admits to it. And let's talk about that. Let's talk about what the defendant admitted to. What's the first thing he said? And y'all heard this on video. How much he had to drink tonight? Not too many. Officer Braxton pressed him a little bit more. 1 or 2. 1 or 2. I would submit to you that if he doesn't know exactly how much he's had to drink, I submit to you that that's evidence of impairment. But what this more likely is that that's all he is willing to admit to. And if he wasn't impaired, he would have just said 1. He would have just said 2. This was the defendant's opportunity to at least try and cover his tracks a little bit. But use your common sense. Use your common sense. Let's talk about what was on camera. You can watch the video as many times as you want. It's in evidence. If y'all want to watch it again, you're more than welcome to, and I encourage you to. Watch the defendant when he walks past the camera. Even with people leading him, I submit to you, he's unsteady on his feet. When he's in the jail, he's leaning up against Officer Braxton's car. Defense counsel says his speech isn't slurred. I would encourage you to listen to the video again. Listen to how he talks, especially when he's being questioned about implied consent, especially when he's being questioned about the breath test. Listen to the way that he's talking. And you decide whether or not you think that his speech is slurred or impaired in any way. Not having a breath test here is not a lack of evidence, it is evidence. As you heard in the implied consent form, the defendant is told a refusal to submit can be used as evidence against you, as consciousness of guilt. And that's what this is. I know in jury selection we talked about the kid with the paint on their hands. I know it's a silly example, but it's the same concept. You know, you come home, there are red handprints all over your walls. You ask your kids who did it. All of them have their hands behind their back. The one that's keeping their hands behind their back, that's not showing you their hands, guess what? They've got it on their hands. This defendant knew what was on his hands, but he wasn't showing because he knew that he would have been caught. He gave up his privilege to drive for a year for free so he didn't have to show his hands. You want to talk about exercising a right, okay? That's fine. It's a pretty important privilege he gave up, his privilege to drive. We talked about how important that is in jury selection, and he gave it up for free so he didn't have to show his hands. As I said, this refusal, the driving pattern, the officer's testimony, the defendant's admissions to drinking, the smell of alcohol, the glassy eyes, the unsteady on his feet, all of these are pieces of evidence that put together a puzzle. Once you put those pieces together, taking them all together, I'm confident that the only verdict you'll reach is a verdict that makes sense, and that is consistent with the law, and that's a verdict of guilty.
In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreman who will preside over your deliberations. The foreperson should see to it that your discussions are carried out in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring that verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside of the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communications such as blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given you in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any other types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote on the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for an answer. I will answer any questions if I can, or in writing, or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. If you wish to see the video, please request that in writing. In closing, let me remind you, that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. Before you go back, I need to release the alternate juror. So, Mr. Reck, you are the alternate juror. Thank you for paying attention throughout this trial. I appreciate you sitting here. I hope you don't feel that we've wasted your time. If you want, you can go and stay and wait to see what the jury verdict is. If you want to leave but are still curious, you can give your number to the bailiff and she can give you a call and let you know what the verdict is. Okay? Do you have any personal items you need to take with you? No. They're in the room? Okay. So I'm going to let you go back and get those and come back out. You can go ahead and sit out in the audience for a second. All right, Madam Clerk, you have the exhibit. State and defense, this is the only exhibit that's going back. This is the implied consent. Here's a copy of the verdict form.
Yes, sir.
All right, ladies and gentlemen, the bailiff's going to take you back to start your deliberations. All right, you may be seated. Mr. Zaleski, you've been in court this whole time and sitting at counsel table. Are you satisfied with the representation of your attorney?
Yes, sir.
Are there any things that he did that you didn't want him to do or anything that you would have done differently?
No, Your Honor.
All right. So the jurors, what is it, 3:35, they went back. Just don't stray too far. If you do stray far, just make sure that somebody has your phone number to call if we have any questions or a verdict.
Yes, sir.
And we will be in recess.
Thank you, Judge. Question?
Have a seat. So they have asked to watch the video. Well, the state wants to go ahead and get that fired up.
Yes, sir. Can y'all see it?
I can see it on that one. I can't see it on my screen.
Can I see
Is
it?
it on these?
He did,
Something about having to turn it off.
yeah, he did something in this little box here.
Yeah.
Yeah, that's way beyond my technical.
Yeah.
Just shake them.
Get electrocuted.
Maybe try and hit play and see if it
it'll do anything.
Yeah. Nope.
Did you call it? No. It's on? Okay.
I don't care if mine's not on, I can look at that one, as long as those are on.
Is it all of them? Okay.
Yes.
All right. Is everyone ready to bring the jury back in?
Yes, Judge.
You can go ahead and bring them in.
All rise to re-entering the courtroom. Judge Joe, we're going to switch positions a little bit so we can get closer to the videos to see.
Get all the way to end.
Yeah, there's three TV monitors, so just go to the end so we get
Yeah, if you want to cluster around a monitor, that's fine. All right, ladies and gentlemen of the jury, you asked if you could watch the video, so we're going to play that for you now. Sorry, you see me.
Is it working there? What's your name? Matthew. What? Matthew? Oh, I don't know what's your name. Nothing to you. Yeah, Matthew. Hey, walk this way with me. Jump on the sidewalk for me. You got a weapon or anything like that? No. Hey, come on. Alright. What would you get stopped for? Oh, you got record? Good, I can sure. And I was, okay. What are you going for tonight? I'm going to midnight. Midnight? What you doing over there? I was just looking at your friends and also, which bar were you at? I was down there for this afternoon. Good job, you drink it tonight. What's not the minute? I had about 1 or 2. 1 or 2 what? Beer. Beer? Sure. And you had 1 or you had 2? Usually when people say 1 or 2, it's going to be the latter. Even though I answer them. You ever see shots or anything like that? Or mixed drink? How long was the average drink? I thought it was just at 12. Yeah, at 12? Yeah. Think you'll get it done? I thought it was okay. Thought it was okay? I think it was okay. I think okay now? The bowl is here. We can use the bowl and eat the renew. That's okay. Do you think you find something you know about? Sure. And that is kind of fast and careful. No needles, no drugs. You guys like the number? your implied consent warning on that. Have to read your implied consent warning. What does that mean? I'm about to read it down. I'm now requesting that you submit to a full test of breath for the purpose of determining the alcohol content. We take the test. I'm not doing that on the record. Oh, you have a big test? Not on the record. Because the attorney has nothing to do with this part, right? I need you to, I can't. Understand? It's your review. All right, if you could submit to the test that I'm requesting you, your privilege to operate a motor vehicle will be suspended for a period of 1 year for your first refusal, or 18 months if the privilege has been suspended as a result of refusal to submit to a lawful test of your breath and your blood. Additionally, if you refuse to submit to the test, I'm requesting you, and your daughter's privilege has previously requested, previously suspended for prior refusal, submit to a lawful test of your breath and your blood, you'll be committing a misdemeanor. Refusal to submit to the test I requested is admissible into evidence in any criminal proceeding. If you still refuse to submit to this test, knowing that your driving privilege will be suspended for a period of at least 1 year, and you may be charged criminally for subsequent refusal. Yes, I can say that. Attorney Bird.
All right. Madam Baker, would you please take them back and resume their deliberations? May we see them? We will be in recess. They might have another question. So.
Yep.
All right, maybe not. All right, you have these. Okay, I have 2 questions. First question is, what day of the week was September 3rd, 2018? The second one was, why was the 3rd police officer not in court?
Can't answer.
Yeah. No. So I'm just going to say we can't answer these questions. You need to rely on the information that was presented at trial to finish your deliberation. Something of that nature. I'll bring them in, just give it to them orally if that's all right with everyone.
Okay.
All right, let's bring in the tree.
Thank you. They want any phone? Maybe it's going to take them half all the days to figure it out. But no, I'm going to be
days.
Right, right.
There's like a leap year in there.
Yeah.
Well, you can worry about some of the county. Oh, yeah, I can do that. Yeah, they can. You can help them respond to that.
All rise, jury entering the courtroom.
All right, you may be seated. So the bailiff has given me two questions. The first is, what day of the week was September 3rd, 2018? We cannot answer that question. We'll just have to rely on the information that was presented either through testimony or exhibits in your deliberations. The second question was, why was the third police officer not in court? And it's the same. We're not able to answer that question, so you just need to rely on the evidence that was presented in court through either testimony or exhibits, okay? All right, thank you. You can go back and return to your deliberations. All right, we'll be in recess.
Back in session.
All right, be seated. We have a verdict. Any issues before we bring them in?
Nothing from the state, Judge.
No, Your Honor.
All right, let's bring them in.
All rise, jury entering the courtroom.
All right, you may be seated. For the record, the jury is back in the courtroom. Has the jury reached a verdict? All right, can you please hand the verdict form to the bailiff? All right, Madam Clerk, if you could please publish the verdict.
In the state of Florida versus Matthew Zaleski, case number 2018 CT 1871, we, the jury, find as follows as to count 1, driving under the influence. The defendant is not guilty. So say we all, this 23rd day of June, signed by the foreperson.
Thank you, Madam Clerk. You can have a seat. Ladies and gentlemen, I wish to thank you for your time and consideration in this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon jurors for consideration of difficult cases. We have recognized for hundreds of years that juries, deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. Thank you again for your service. We greatly appreciate it. We couldn't do this without you. You can go ahead and pick up your devices, and the bailiff will help walk you out. Thank you. You may be seated. Mr. Zaleski, the jury having found you not guilty of driving under the influence, the court now judges you not guilty, and you may go hence without appeal. All right,
Thank you.
any other matters for the court?
Another from the state, Judge.
No, Judge. Thank you.
Have a good evening.
Yes, sir. See you.
You too, Judge.
Let us know your thoughts about this trial and about the result. Sadly, it seems that Mr. Zaleski has not learned anything from all these arrests and convictions for DUI. Rather, the opposite seems to be true. He's still putting his apparent love for alcohol ahead of the safety of others. Just a few months after his acquittal for the 2018 arrest. On March 24, 2022, so a few months after this trial, Mr. Zaleski was again driving drunk in northeast Tallahassee. That time, he caused an accident, a head-on collision with a vehicle driven by a woman who later became my client. The woman's car was destroyed and she suffered significant injuries. Mr. Zaleski was injured as well. Unfortunately, Mr. Zaleski was taken to the hospital, and the officer who responded to the scene did not charge Mr. Zaleski with DUI. Months later, we found out that Mr. Zaleski actually profited from his DUI and the accident that he caused. He pursued an underinsured motorist claim against his own insurance company, and the insurer paid full policy limits, given the apparent severity of his injuries. Then his attorneys at Fasig and Brooks, specifically attorney Kimberly Hogan, pursued a claim against my client's bodily injury liability insurance coverage. Bizarrely, according to the adjuster who was handling that claim, the demand package included a copy of a medical record showing that near the time of the accident at the ER at the hospital, his blood alcohol level was 0.271, several times higher than the limit that would be required for a DUI arrest. After I contacted Ms. Hogan about this issue, Ms. Hogan withdrew her demand and requested that my client's insurer not give us a copy of the medical records attached to the demand. The lawsuit was then filed, and Mr. Zaleski is pleading the fifth and is refusing to answer questions or turn over documents that would prove that he was drunk at the time of the accident. Due to this accident, my client still suffers from her injuries, and her medical bills exceed $60,000. Of course, we cannot blame the jury in this case for acquitting Mr. Zaleski. They did their job, and I respect their decision. We cannot blame them for the accident that happened a few months after the trial, after this acquittal. The only person to blame here is Mr. Zaleski. We hope that by publishing his trial, he will finally do something to take ownership of his problems with alcohol and operation of motor vehicles. If he wants to drink, alcohol is legal. Just don't get in a car and drive. Have a designated driver or use a car service. We hope that no one else will ever be injured because Mr. Zaleski decided to drink and drive again. Be safe out there, mentor, lawyer, and ladybug. Until next time.